Okay, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores.
Present.
Senator Orenshall.
Here.
Senator Lang. Senator Nguyen. Senator Hansen. Senator Krasner. Senator Ellison. And Chair Scheibel.
And I am here. Thank you very much. We do have everybody present on our committee today, and we have one bill on for a hearing this afternoon. We are delighted to invite our Majority Leader to the Senate Judiciary Committee, I think for the first time this session. And please make your way down to the front table, and whenever you are ready to present, please go ahead and get started. Introduce us to your co-presenters, and I will now open the hearing on SB 263.
Thank you, Madam Chair and members of the Senate Judiciary Committee. For the record, my name is Nicole Cannizzaro, and I serve as a senator from Senate District 6 in the northwest portion of the Vegas Valley, and also as your Senate Majority Leader. And I am pleased to be here today alongside Attorney General Aaron Ford to present to you today Senate Bill 263, which revises provisions relating to pornography involving minors. I am sure that you have all heard of deepfake technology, and I think you had similar hearings in this committee around the use of AI technology, this same technology uses what we refer to as AI, artificial intelligence, to manipulate audio or video to create a false but very realistic video of individuals doing or saying things they did not actually do or say. For example, a person's face can be swapped with another's, and lip syncing can be added. Machine learning and sophisticated technological tools have made deepfakes relatively easy to create and increasingly commonplace in recent years. These advancements in AI have introduced new challenges for law enforcement, as I'm sure does not surprise this committee. For example, generative AI modules are image, audio, video, and text generating platforms that can generate many types of synthetic media. Unfortunately, the rapid advances in generative AI have been leveraged to produce what we also refer to at times as child sexual abuse material. To combat the proliferation of AI-generated child pornography, Senate Bill 263 modernizes Nevada's existing child pornography statutes to keep Nevada's children safe. This gives law enforcement the tools they need to prosecute and deter the spread of AI-generated child pornography. Senate Bill 263 covers images of actual children and images that are indistinguishable from a child. This type of material certainly victimizes children, and I think that's the main reason why we are here before you today. It exploits these children for sexual purposes and absolutely should be against the law. With the chair's permission, I would like to briefly walk the committee through each section of the bill. And so we'll start with Section 1. Section 1 creates a definition for computer-generated child pornography to include an actual child or an actual person 18 years of age or older adapted to look like a child, used as a subject of a sexual portrayal, engaging in, simulating, or assisting others to engage in or simulate sexual conduct. The term also includes, for the same activities, any visual representation that appears to depict a child that is created by the use of AI or computer technology capable of processing and interpreting specific data inputs to create a visual depiction that is indistinguishable from a minor. The term indistinguishable is defined as virtually indistinguishable, such that an ordinary person viewing the visual depiction would conclude the visual depiction is of an actual minor. Section 2 of the bill expands the prohibition against the preparation, advertisement, or distribution of child pornography to include computer-generated child pornography. Section 2 also revises the applicable criminal penalties by 1, subjecting each person found guilty of violating the prohibition to a term of imprisonment in state prison, and 2, providing that a person who is found guilty of a second or a subsequent violation is guilty of a Category A felony, punishable by an imprisonment in the state prison for a minimum term of not less than 10 years and a maximum term possibility of life with the possibility of parole. The person may also further be punished by a fine of up to $15,000. Section 3 adds computer-generated child pornography to the prohibition against the possession of such material and increases the penalty from a minimum of 1 year to 5 years in a state prison for a second or a subsequent offense. Section 4 makes a conforming change to the definition of sexual offense in regard to the application of the law regarding a person to register as a sex offender. With respect to the remainder of the presentation, Madam Chair, with your permission, I would like to turn the presentation over to our Attorney General, and I also wanted to note that we do have with us, just for questions later on in the presentation, Chief Deputy District Attorney Jacob Villani to answer any technical questions as he does practice in this particular type of prosecution. So with respect to the remainder of the time, I would like to turn it over to our Attorney General.
Thank you very much, Senator Canizaro, Majority Leader Canizaro, and thank you, everyone, Chair Scheibel, members of the committee. My name is Aaron Ford, and I am your Attorney General. Thank you to the committee and Majority Leader Canizaro. Thank you so much for allowing me to speak in support of this important bill. It's simple. Our laws need to keep up with technology, especially when bad actors are using it to exploit children. SB 263 closes a very dangerous loophole, and I'm here to make sure that we do exactly that. Creating computer-generated child pornography is not just disturbing, it's predatory, and it should be a crime. Under this bill, it will be. Using AI or any other technology to exploit children by manipulating their likeness is a deliberate act of harm, and there should be no loopholes that let predators get away with it. And again, this bill will ensure that they won't. And this isn't a victimless crime. When predators use AI to create child pornography, they're not just breaking the law, they are actually re-victimizing real children. No child can consent to this, and no survivor should have to live in fear that their likeness is being used in this way. We've actually already seen how devastating this can be. Let me give you a real-world example of why this bill matters. A child who was rescued from sexual abuse in 2018 is still being victimized today because predators are using AI to create new fake child pornography with her face. These deepfakes keep the abuse going long after she was saved, and because of advancements in artificial intelligence, it's actually harder to ever track and remove these images. This bill would put a stop to that. It bans AI-generated child pornography, closing a loophole that predators are exploiting. Beyond the obvious moral outrage, there's also a practical reason for this too. Law enforcement has to treat every AI-generated image as if it's a real child that is being harmed. That takes time and resources away from actually finding actual victims. Right now, investigators are stuck determining whether these images are real instead of focusing on protecting kids who desperately need their help, and that's unacceptable. And here's the legal reality. Under current law, prosecutors could struggle to go after offenders creating this material because existing statutes weren't written to cover AI-generated images. The law depends on clear definitions, and right now, terms like person and minor may not account for this new technology. And these are gaps that give predators an out. We can't let that happen, and so as technology evolves, so do the threats against children. And as we stated, this technology is creating problems that we never thought possible, and if we don't act, it will only get worse, and our laws have to keep up. SB 263 closes this loophole, and it makes sure that predators can't hide behind AI. It protects children, and it ensures that law enforcement can focus on what really matters, rescuing victims and putting criminals behind bars. This bill has my full support. I urge this committee to pass it, and I want to thank Majority Leader Canizaro again for her foresight in bringing this bill. Thank you so much for having me here to testify.
Thank you, Madam Chair. Nicole Canizaro, Senate District 6. Just in closing, I do want to thank the committee members for taking the time to allow us to present Senate Bill 263. The use of AI is fast evolving. I think that is an important note with respect to this piece of legislation. We do not have the time nor the luxury to wait to address this important issue. The longer we wait to put a stop to computer-generated child pornography, the more it will advance and spread, resulting in harm to children in this and other places. I urge your support of this vital legislation, and I think one of the reasons why this piece of legislation and why you are seeing the two of us up here is because this is something we absolutely have the obligation to address. To wait another 2 years or to wait and see what happens with adaptive AI technology, it simply allows for the victimization and exploitation of children here in Nevada. And it is something that without this tool, I think you will find that law enforcement has their hands tied in being able to address it and to address it in a meaningful fashion. And so I know there are a lot of questions and concerns. I've been having some of these meetings with folks to discuss some of those, and I'm sure that we will have a very robust discussion about it today. But at the end of the day, I think the one thing I want to sort of put some emphasis on is that this is a real problem. Where law enforcement is encountering this type of material, if they cannot definitively say that it has not been altered by AI, and I think to the Attorney General's point, if it has been even a little bit altered by AI, it does not fall within the realm of what we have in current statute. We have to address this. It is going to become a much more widespread problem if we don't, and I think that Senate Bill 263 is a solution to that. So with that, Madam Chair, I would love to take any questions that you or the committee members may have. And of course, the Attorney General is here to the extent that he can answer some of these questions, and we have assistance from a prosecutor in Clark County who works within this particular field as well for any technical pieces that he may be willing to add. Thank you, Madam Chair.
All right, thank you. Thank you both so much for your presentations. I am likewise sure that we will have some questions from the committee. I will start with Vice Chair Flores.
Thank you, Madam Chair, and thank you both for the presentation. Obviously, this is something that terrifies every single human in this state, so it's a conversation that we have to engage in. I was curious, I know the landmark case of Ashcroft 2002 is really what we all go back to, and I know there in doing the Ferber test, they really focused on actual versus just kind of a human that's created, right? And I see in section 1 here, you're using an actual human. I'm curious to know, and maybe our technical expert that's joining us can help us, in prosecuting these cases, how do you identify the actual child, right? I'm assuming that may be difficult at times, but imagining that scenario where there's a website or a particular individual who has a lot of content, right? How do you distinguish in that scenario where the actual child is so that we can identify that victim? And then, Madam Chair, if I may have a follow-up after that.
So the vast majority of our investigation.
Sorry, you have to put your name on the record every time you speak.
Oh, I'm sorry. Jacob Villani with the Clark County District Attorney's Office. So the vast majority of our investigations are launched via what are called NCMEC tips from the National Center for Missing and Exploited Children. NCMEC keeps a log of all known child pornography images, and they do what's called a hash function on them. A hash function is essentially a fingerprint for an image. So when online entities such as, Google Drive or X or Facebook, whatever, come across one of these hashed images, they report it to the National Center for Missing and Exploited Children, and our investigations are launched off of that. We then seek the IP addresses and that sort of thing. So the way we identify the children right now is they are known images. These have been investigated. These have been confirmed as known children, and these images are hashed there. Now, if you change a single pixel of these images, it hashes differently, which is part of what AI kind of complicates throughout this process.
And Madam Majority Leader, I know that you were cut off. I don't know if you wanted to add to some of that.
Thank you for the question, Senator. Nicole Cannizzaro, Senate District 6. Through you, Madam Chair, to Vice Chair Flores.
Please go direct.
Thank you, Madam Chair. So I think one of the things that you brought up in your question, Mr. Vice Chair, was the Ashcroft decision, and where I think we'll definitely probably have discussion. I'm sure you will hear from others with respect to that particular decision. And so a couple of notes that I wanted to make for the committee. First and foremost, protecting and guarding against the exploitation of children for sexual material purposes absolutely is a compelling state interest. That is something that this state has, I would argue an obligation and a duty to do. In addition to that, I do believe that there is, without a doubt, a strong case that the state has that very compelling interest. And so when we look at the Ashcroft decision, I think a couple of things we want to note. That was interpreting a federal statute that made no distinction between an actual child or something that was completely made up. In that decision, the Supreme Court noted that because that statute was not accompanied with certain parameters from Ferber and Miller with respect to obscenity, that there were constitutional questions about that particular statute. I would note that currently in Nevada law, and you will see the text of which in Senate Bill 263, in Section 1, if you go into what would now be under the proposed language, subsections 3, 4, 5, and 6, you actually have those parameters that currently exist within Nevada law for that test, so that we are not doing in this bill what was struck down by the Ashcroft Court. And I would direct this committee to review the decision in United States versus Williams from 2008, subsequent to that Ashcroft decision, where they actually make this distinction in noting that because we are now talking about where you are drawing this line, and I know we're going to have some more discussions about where these lines are drawn. I think the difficult part about legislation and the law and lawyers, which this committee is very familiar with, is that it's very hard to draw clear, bright lines in almost anything. And so what we have here, I think, are the parameters that the court looked to in the Williams decision, that the court was looking for in that Ashcroft decision to say that we are guarding against First Amendment violations by noting that there are parameters around that when we talk about whether it falls within this category of being obscene material. And so I wanted to just note that because I think we are going to have a lot of discussion on that topic area, and I know that your question sort of started from that position, and so that's what I was going to add before going to Mr. Villani with respect to the technical pieces of how it is they're conducting these investigations. So thank you, Madam Chair, and thank you, Mr. Vice Chair.
Madam Chair, if I may continue, and thank you for that. And I know that 2008 case obviously gives a lot of direction to, in kind of dissecting Section 1 and talking about indistinguishable, and I'm trying to understand, in with all respect to some of my friends on social media, when they utilize these AI apps, I know it's that person, but I don't know it's that person. I'm like, that looks so completely different from you. And respectfully, we all see those filters on there and we joke around. I'm like, there's like 14 filters on that human being. But I start with that joke, but then get into the serious conversation of, you know, when we're trying to try one of these cases, and I understand that there's a database, so that makes it a lot easier to engage in some of these conversations, but I'm trying to, how much leeway are we giving an individual who's engaging in this activity that we're trying to prohibit from having those outs, right? Because I feel one filter, two filters, three filters, AI, do we open the door for some of these conversations to say it's not that individual anymore? Do we have the technology to be able to trace it back to the original actual person? I'm just curious to know how we see ourselves kind of engaging in that particular type of case where now it's so far removed from the actual person, or that filter, if put on 14 different people, all 14 people may look the same with that filter. I'm curious to know how we see some of those scenarios playing out. And I meant to send that up to her via Zoom a friend.
Okay. Jacob Villani, we're at the Clark County District Attorney's Office. Sorry, I did not know that was directed to me. And as I was mentioning before, these investigations aren't launched by just looking at the images. So in your scenario, we would be relying more upon kind of an AI-generated child. So we're seeking to, there's kind of a twofold thing we're looking at here. So is it an actual child that has been modified with a computer image, or is it an AI generated child? So in the circumstance of an actual child and the filters you're talking about, that would keep that image from being hashed. In other words, these are how our investigations are proceeding. So if it's an actual child and there's an actual child in the home that resembles that image, that would go down to the investigation. Do these filters go back, even though this is a heavily filtered image, does it go back to that child? I'm not sure if that addresses your question, Senator, but.
Thank you. And I think we're probably agreeing that in a lot of instances, it's going to be incredibly difficult to identify the actual child. And I was just trying to see if there was an alternative mechanism that I'm just not familiar with. Technology, whether it be a technological type of application that you use that can help extract the original image from the alterations. Because my understanding, I don't believe that exists, but maybe there is. And I was just trying to understand how some of these scenarios are going to play out, and that's the reason I was bringing it up. But I get it. You're going to start off. Do we have an actual child? Period. Yes or no. If we're so far removed from that, unfortunately, we're not capturing that in this bill, if I'm understanding you correctly.
Sorry, if I may, Madam Chair, Nicole Canizaro, Senate District 6, to you, Mr. Vice Chair. I think that is part of what this bill is driving to get at. Under current law, if that were the case, and it now no longer can be identified to an actual child, in the instance of an investigation where maybe that hash is changed, we are at a loss to address that. And again, the state has, I think, an obligation, certainly a compelling interest, in ensuring that this sort of exploitative material is not being distributed, generated, freely given within and among people. And that's one of the issues that I think AI presents, and one of the problems that this bill is trying to solve. If they were to find an investigation where someone has now taken an image of an actual child and changed it such that it is not showing up in these investigations in the way where it was a known item and now no longer is, this bill would allow for law enforcement to still conduct that investigation, and if they have the proof that meets all the elements contained within Senate Bill 263, to then prosecute that individual. And I think that's part of the problem that we are trying to solve, because right now, and to the Attorney General's point in his testimony, there is this loophole that exists that is superficial in nature and that ignores the victimization and exploitation of these children. And I think that that's part of what the impetus of this bill is exactly the scenario which you're describing.
Thank you, Madam Chair. And the last question, and I understand that on the sub-C side, and I was just focusing on that subway. Is there a way now when we move away from, so this is, the conversation started with the actual, and I understand. And then when we move into the sub-B section of it, if we show somebody a picture and we try to play that game of guess the age, right, 17, 18, or 19, how do we foresee those conversations moving in that particular kind of climate, in this conversation, whether we're going to cut one way or the other and we're going to pursue it all the way? Have we kind of walked through that hypothetical if we engage in that sub-B part of the bill?
Thank you for the question. Nicole Canizaro, Senate District 6, to you, Mr. Vice Chair. I think that's going to be a lot of the conversation around this bill. And I think you'll hear from folks who have opposition to the portions of the bill. The reason why this language, though, is drafted this way, and I will talk about just a couple of things. Number one, when you look at the decisions from the United States Supreme Court as it regards these sorts of things, where we're talking about indistinguishable from a minor, there's an implicit acknowledgement. And in fact, in Ashcroft, the Supreme Court noted that there are not bright lines here, right? There is a very big difference between a 3 or 4-year-old, where we all acknowledge that is in fact a minor, that is a tiny child, and someone who may be of an adolescent age, and whether or not there's a distinction there. I think layered on top of that, and one of the reasons why the statute in Ashcroft was found to be unconstitutional, and why they pointed to some of these pieces, whether it meets these obscenity standards, which was not present in that statute, was because they acknowledged that, for example, a film that may show a sexual encounter between two adolescents, but that overall has artistic value, when we look at that as a whole, is a very different scenario than what we are talking about when we are trying to get at and to target material that sexually exploits children and minor children. These sorts of, if we are looking for bright line tests in legislation, where we are going to say, we wrote this bill and exactly this is what is going to happen, there are very few, and I would argue with this committee, you probably know more than most, that we are writing laws that are bright line tests one way or the other, right? And that's why it's important that when we do draft legislation, that we have parameters around that. Currently in Nevada law, that is why this, when you talk about child pornography, and as it relates currently under NRS 200.700, right? Those subsections that talk about whether it is a sexual portrayal and whether or not it appeals to the prurient interest, whether or not it has any serious artistic, political, or scientific literary value, those are the kinds of things that when we talk about whether or not this violates a constitutional right to free speech, we can answer those questions. Some of these cases are going to be on a case-by-case basis. You cannot get around that. Just like we have statutes that say first-degree murder includes premeditation and deliberation. What constitutes premeditation and deliberation? If it is instantaneous, if it is long and drawn out, those are the kinds of things that we are accustomed to in this committee hearing, in this body hearing, passing those types of laws, and lawyers are, and investigators and law enforcement are in the business of ferreting out. And so I think when we're looking at a bill and what we're trying to do here, we're not going to solve every particular situation of whether or not somebody is falling within that lines. I think you have to take a holistic approach to it. And in this bill, we are trying to get at instances where you may have someone where that image has been altered and that maybe you're playing that guessing game. But some of this is going to have to reside in what we know as common legal principles of evaluating things. The question is whether or not we're writing a statute that gives some clear directives as to what sort of conduct we are trying to prohibit, and whether or not there are enough parameters such that we're not infringing upon constitutional rights.
And thank you, Majority Leader, for that. And I think that, because I've heard from the opposition as well, but I think just in the exercise of just focusing on an actual person, we pulled out and dissected that even there it could be very complex, that it's not a clear cut, we're going to be prosecuting, every single individual on that potentially falls in this gray area. It is going to be difficult. There's going to be a lot of resources that need to be utilized in every one of these cases. And I appreciate indulging me with the questions, Madam Chair. Thank you.
Senator Hansen.
Thank you, Madam Chair, and thank you, Majority Leader and Attorney General, for bringing the bill. I think this is definitely bipartisan in scope. We heard a bill yesterday from Senator Stone on a very similar related topic, and I sincerely hope that you guys all get together and we can have a bipartisan bill on this issue. Listening to the discussion, I was reminded of something Maggie Carlton told me a long time ago, and that was, don't let the perfect stand in the way of the good. And I think the bill overall is very good. And when I think of Senator Stone's interest, and I know the governor with his strong law enforcement background undoubtedly is very supportive of the concept. However, there is a proposed amendment from the public defenders, and I wanted to find out, number one, if you guys are familiar with it and if you consider it a friendly amendment, because a lot of the issues that are raised over First Amendment protections and things like that, I think they're trying to address. So I'm just curious as to whether or not you guys had a chance to look at that and whether or not you're going to consider incorporating it into the bill.
And thank you, Majority Leader, for that. And I think that, because I've heard from the opposition as well, but I think just in the exercise of just focusing on an actual person, we pulled out and dissected that even there it could be very complex, that it's not a clear cut, we're going to be
Thank you for the question, Senator Hansen. Nicole Canizaro, Senate District 6. So I want to first thank the Public Defender's offices from both Clark and Washoe. They did come, they did meet with me, and we talked through some of these questions and concerns. At this point in time, the amendment is not what I would characterize as a friendly amendment. It's not what I'm presenting here. Obviously, we're still engaged in conversations, and I understand the concerns. I think they're probably the same concerns that this committee rightfully should have, whether or not what we are putting forward makes sense, whether or not it violates the Constitution. I would just start first with Senate Bill 263 does not constitute a constitutional violation. I think, and certainly in their letter, which I think this committee may also have, and if not, I would be happy to provide it. I'm getting a nod that I believe it was posted, so you all should have a copy of that letter. There are concerns raised as to the constitutionality of Senate Bill 263, and a lot of relation back to that Ashcroft case that we have discussed a bit. Under Ashcroft, there was a federal statute that was designed to get at addressing issues relating altered images of child pornography. There's also a citation to an Illinois case as well that is different in nature. In that case, the specific instance involved cutouts from a parenting magazine and then sort of a makeshift pornography play out with those images from the defendant and whether or not that itself would constitute child pornography. I think there are differences in those two cases. One, subsequent to Ashcroft, the Supreme Court heard the Williams case, which interpreted a federal statute. It's 18 USC 2252A, which was specifically passed in response to that Ashcroft decision. That is very similar to language that we have here, not exactly, but I think that we are achieving the same thing. So with respect to the constitutionality concerns, I do not believe that those exist with respect to Senate Bill 263 because we are not just flat out saying any sort of possession of something that could be considered minor pornography or child pornography constitutes a violation. We are acknowledging that it also has to fall within it also has to pass these obscenity tests, right? Whether or not it appeals to the prurient interest, whether or not it has literary, artistic, political, scientific value, whether something as a whole falls within those commonly known and regularly used constitutional protections. That is current Nevada law. That applies to this particular expansion of the definition. What Senate Bill 263 is seeking to get at, I also think, is broader than what the amendment that was presented from the Public Defender's Office is looking to get at. Under their amendment, which mirrors some federal language, but not that was upheld in the Williams case necessarily. And so anyway, they're trying to get at some language that would have to relate back to an actual child. As you have heard today, some of the uses of AI technology make that virtually impossible to do, even if it does relate back to an actual child. And so that's sort of complication number one. And complication number two is that a lot of this is being done for the same purposes, right, but is using and overutilizing that AI technology. And so I believe that if we were to accept that definition that was presented from the Public Defender's Office, we solve maybe part of the problem, as long as you can still get back to that same identified child that Mr. Villani was talking about with respect to those investigations, which maybe solves a small piece of this problem, but does not solve the problem that we are seeing with AI technology, which is you can alter that image so that you cannot trace it back to a real child, but that it does stem from that, or it is intended, right, to exhibit the same features as a real child and is still sexually exploitive of minors and still is within the parameters of this body and this state to police that sort of conduct. And so I think the harms still exist under their proposed amendment. I don't think that the constitutional concerns necessarily meet when you look at Senate Bill 263 as compared with some of the cases that they have cited. I think we have addressed those constitutional concerns. And I don't think that we solved the entire problem. So at this point, that amendment is not something that I am putting into Senate Bill 263, but definitely want to thank them for coming to me and for talking, and we've definitely had those conversations.
Great. Actually, I wasn't pushing the amendment. I just wondered if you guys had actually had a chance to discuss it. The constitutionality, I'll leave up. In fact, Mr. Wilkinson and I had an interesting discussion about that. He and I both agree. This is my eighth time on Judiciary, 8th session. And this is the first time I recall this in-depth of a discussion on a scientific technology that has such almost bizarre potentials. So we both suspect that because there are federal laws dealing with this now as well that have not been constitutionally challenged. So we do expect in the not too distant future that the United States Supreme Court will address some of the issues you just brought up. But obviously, if the issue is you have to have a real child to start the whole process, then we don't even need to discuss this issue. We already have laws against that. We obviously need to go forward on the artificial intelligence ability to actually create such a realistic image that you can't tell it is not a live child. So totally on board. I do hope, though, as we go forward, this is recognized more as a bipartisan effort. I can guarantee you everyone from the governor on down wants to have this addressed. Like I said, this is the first time and this will be 8th term, so, going on 16 years of being in this place that we've had to deal with this gray area of law, no serious constitutional decisions by the United States Supreme Court. So there's a lot of areas moving forward. But again, I think the bill's right on the money as far as where the need we need to go. If we can work out some of the potential constitutional bugs in advance, that would be wise. But like I said, like Maggie always said, this is a very good bill, maybe not perfect, but we need to move this idea forward. So thank you, Madam Chair.
Madam Chair, if I may, Senator Hansen, Nicole Canizaro, Senate District 6. So I think there are a couple of things. First, obviously, we've seen a lot of bills that are sort of within and around this vein. I want to thank the Attorney General because we were both sort of, I think, independently working on this issue. As we know, and certainly him being in our top law enforcement spot, if you will, for the state, has folks who work on this sort of issue. This was something that was brought to me from law enforcement as well, and I think you've seen there are a number of assembly bills. We have added some assembly members on this bill as well. It is a bipartisan piece of legislation because I think there's a recognition that this is an issue we have to address. And so I think 16 years on this committee certainly makes you a bit of a seasoned professional, if you will, on judicial issues, but certainly I think the fact that there are so many bills that exist certainly speak to why it is we do need to update our laws here in Nevada. And so I just wanted to take a minute to note that there were a number of people who were very gracious in helping to come up with Senate Bill 263 and who've been working on this issue, and we recognize those concerns, and it includes our Attorney General, it includes our Assembly members who signed on to this. Assemblymember Hardy and Assemblymember Dahlia also were sort of working on some similar legislation, and we've sort of combined our forces, if you will, to all be sponsors on this bill and hopefully move something meaningful and balanced forward.
Madam Chair, I'm in full agreement with that. So let's move forward in a bipartisan fashion.
Thank you both. I think Senator Nguyen also had a couple questions. Go ahead.
Thank you. It sounds like you found a new co-sponsor as well, potentially more. I just want to thank you for bringing this piece of legislation. I think it is very forward thinking. I think it's adapting to this scary technology that is out there. And I'm learning some new things. And so I have a couple of questions. One for probably Mr. Villani about, you had indicated that currently a lot of your investigations and your cases arise from hits from this database that are hashed. Do you have an idea of how many, I guess, AI altered images that you don't get access to, or are they available on the database as well? Or would you have to develop a new database that also incorporates some of these either AI altered images of real individuals or some of these AI images that are so like real life that you wouldn't be able to distinguish between the two of them?
Jacob Villani, Clark County District Attorney's Office. Thank you, Senator Nguyen. So our investigations are launched by the NCMEC hash matches that you mentioned. Once those hashes are matched and the IPs are identified and the location is identified, there are then search warrants executed for various devices. Now, I've come across a couple cases so far where when those devices are examined, there is real and AI-generated child pornography on these devices. As far as a NCMEC database and whether or not they are hashing AI images, I can't speak to that. I honestly don't know if they are or not, but I've just come across it in a couple of my own cases.
So is it fair to say that potentially there's even more of this child pornography that is out there, that we just don't have the technology to keep up with other technology in identifying potential victims that are out there?
Jacob Villani, Clark County District Attorney's Office. Yes, that's absolutely fair to say with regard to both real and AI-generated child pornography.
Chair, may I ask another question? Okay. What I actually appreciate about this bill is that it does expand this to visual representations that appear to depict a child. I know that there was some questions and there was some concern over, wonder if you have someone that's like 17 or it's depicted to be someone that's older. At the end of the day, if this law was to pass, prosecutors like yourself would still have to make a call on whether or not they were able to prove beyond a reasonable doubt the allegations that you're bringing in charges like this. Is that correct? Is that my correct understanding?
Jacob Villani, Clark County District Attorney's Office. Yes, that's absolutely correct. And we are overly careful with regard to age when it comes to that. The cases we prosecute are clearly children, from toddler age to young adolescent age. They are clearly children. There's nothing that you would look at and say, well, that's kind of on the line.
And then my other question has to do with even when you have identifiable victims, it is still like a challenge to find those identifiable children when you are bringing these cases. And would this Senate bill, if it was to pass, would it allow you to protect more children that perhaps you aren't able to identify, but it's clear that they are, you know, minors?
It would enable us to protect it in this respect, and that it would help to quell the demand for this type of material, which is really what we're kind of guarded against. When you talk about actual victims, we have circumstances where there's somebody in the home that's being videotaped, right? And so that's an actual physical person that we would have as a victim or survivor of this type of conduct. But there are actual, Lolita type series of well-known child pornography that these people live across the nation, and it's just a well-known actual person, but it's not somebody that's necessarily like a survivor of this possession of these images that this bill addresses. Does that make sense?
It does. And then I guess, again, I appreciate this forward-thinking piece of legislation. I think that I don't have those same constitutional. I think that this is very much distinguishable from those. And quite honestly, I think that the Supreme Court in 2002 and 2008 probably never anticipated that our AI technology would be able to produce images quite like they do now, and in particular that you could have individuals out there creating child pornography without the impact of an identifiable child. But I would agree with you. I think that the fact that these images exist out there and that people are possessing those images harms all children. But that kind of brings me to another question, and this is probably for the bill sponsors. Do you anticipate, or did you have any indication that the possession of these images and videos would also hold these platforms that post and distribute on like a level that we've never seen before, hold them liable as well?
Thank you for that question, Nicole Canizaro, Senate District 6. So obviously this piece of legislation is really seeking to modernize what is currently illegal here in Nevada, which is the possession, dissemination, production, right, of child pornography. And this bill was very much tailored to that specific issue. So this bill doesn't touch on liability parameters or other different things that we could do to hold social media platforms or other internet-based platforms or other places that certainly have this content. And obviously I think that's a very interesting idea, and certainly we should be doing everything we can to protect and guard against the sexual exploitation of children. But this bill was pretty tailored to focusing on giving that additional law enforcement tool as they're encountering this and trying to adapt to that AI technology in the field. And so I don't know if our Attorney General has anything else to add, but I think that that is a very interesting and valid point.
Thank you so much, Aaron Ford, for the record. Senator Wynn, I appreciate that question. Let me answer it by backing up first off, and again, thanking Nicole Canizaro for allowing me to present this bill. I had my own bill in this regard, Senate Bill 35. Brilliant minds thinking alike, forward-thinking, Senator Wynn, as you say, trying to address issues that were brought to our attention. I'm running this bill with her, and it's most appropriate that we do that. I can say, specific to your question, that among the AG circles, both Democrats and Republicans, there are questions around liability in that regard, but frankly, I think it opens up a different kind of worms from a federal level relative to liability, changes to federal legislation, and things of that sort. So even the bill that I ran did not touch on that either. It attempts to do exactly what the senator here is doing, and I must commend her on addressing the constitutional issues up front. This was my chief of prosecutions, Alyssa Engler, came to me with this idea, and she literally went through the elements as laid out in the statute, in the cases, to ensure that the bills that we put forward, the bill that we put forward, was going to qualify and survive constitutional muster. And so I likewise have no concerns with this Senate bill relative to the constitutionality issue, and wanted to mention that as well, even though it was not directly responsive to your question.
No, thank you. I just wanted to clarify that. Like I said, I'm very supportive of this bill. I think it takes us in the step in the right direction. And I'm sure that we will be forward thinking in the future on how we continue to protect our children against predators like this. So thank you.
Other questions? Senator Krasner, go ahead.
Thank you, Chair. I think my question's for Mr. Villani, but I'm not sure. First of all, thank you for bringing this bill. So I'm looking at the bill, and I'm looking particularly at section, I believe it's section 2, and it says that it only relates to computer-generated child pornography, which is disgusting, and a person who violates the provisions of subsection 1, Section 1, subsection 1, for the first offense is guilty of a Category B felony. For subsequent offense is Category A. What about somebody that actually rapes a child? I want to make sure that the actual rape of a child has serious or even more serious penalties than a computer-generated image. And I'm just wondering what the current law is on that, please. Thank you.
So, I think we might both be able to answer some of that question, Senator. Thank you, Madam Chair. Nicole Canizaro, Senate District 6. So I'll take a first stab, and then if Mr. Villani wants to add to that, certainly we would welcome that. So thank you for the question, Senator Krasner. Where you are talking about in Section 2, that addition first of the computer-generated child pornography is allowing for the prosecution under current law to also include this additional definition where we are talking about this AI-generated child pornography, right? We currently have laws on the books that prohibit the possession, use, distribution, production of child pornography. Section 2 is accommodating this new definition. It also increases some penalties, but this particular statute under NRS 200.700 and 200.725, which provides the penalty piece for that violation of the statute, purely applies to the possession, depiction, or possession, production, distribution of child pornography. There are other statutes on our books in Chapter 200 that deal with sexual assault as it regards minors. And so if, for example, I think in one of the examples given by Mr. Villani, where the child pornography stems from actual acts that are taking place in, let's say, someone's home, there are other charges, right? We wouldn't just charge a child pornography violation because that individual has violated multiple Nevada statutes, and so they would also be charged to the extent that there is obviously evidence and an investigation conducted and so on and so forth, charges for sexual assault of a minor, and those do carry very hefty penalties, including the potential for life in prison, just depending on different circumstances. But that type of offense is just currently covered under existing Nevada statutes.
Follow up. So I appreciate that. Maybe my question's for Mr. Villani or for legal then behind me, because also in here it does in section 1, subsection 5, it talks about sexual intercourse. What are the penalties today for the first time somebody rapes a child, and for the subsequent time that they rape a child, is it a category A felony? I think those are my questions. Mr. Villani or legal?
Jacob Villani, Clark County District Attorney's Office. For the first offense, if the child's under 14 years of age, it's currently 35 to life. Second offense is life without the possibility of parole. If the child is under 16 years of age, so in other words, 14, 15, or 16 years of age, it's 25 years to life. We also have lewdness with a minor, which carries a 10 to life if there is no penetration, such that the statute, it's 200.366 is what that's under.
And just one, and I apologize. So first offense, is it a category B felony? And if there is a subsequent offense, is it a category A felony for the rape, the actual rape of an actual child?
Jacob Villani, Clark County District Attorney's Office. They are all category A felonies. So the 35, the 25 to life, those are both category A felonies. The subsequent offenses are also category A felonies. Category A is dictated by the life tail.
Thank you.
Other questions from members of the committee? Okay, I'm not seeing any other questions, so I actually do have a few of my own. It has been a while since I have had the misfortune of handling one of these cases, and so I was hoping that one of you could clarify, currently when we prosecute child pornography cases, do we have to, or do we identify the child, like by initials or by name? And if the case were to proceed to trial, does somebody have to come in and testify to the identity and the age of the child in the depiction?
I'll take a stab at it. Thank you for the question, Madam Chair. Nicole Canizaro, Senate District 6, and I think Mr. Villani probably could weigh in. It has been a while since I had one of these sorts of within that special victims unit cases. So I believe that your question was whether or not these victims are coming into court to testify, which was, I think, maybe the last part of your question.
The victims themselves, or
Yes.
like an expert from NCMEC coming in to identify them?
From what I recall, and again, that's why I'll sort of phone a friend here with Mr. Villani, the Nicole Canizaro, Senate District 6. So in a trial for this sort of thing, which I think, which I know is always very sensitive, just given some of the content, right? We do not, I believe, have law enforcement agencies that are charging actual victim names and having those individuals come into court. I think part of the way in which and why this bill, I think, is necessary is that, yes, they have to identify it to being an actual child for a variety of reasons, but does not require under the statute in a charging document to actually list that child, is that this statute was obviously written well before the use of AI technology, right? And so that's part of the reason why I do think a bill like Senate Bill 263 is so necessary, because this law was written at a time where this was just not something I think anybody could even have thought of, right? So that's the first part of that. And so the second part of this is because of that, it's not that we are having the actual children themselves continue to come into court. And I think you heard from Mr. Villani that some of this is sort of well-documented child pornography that exists across many states and different places that is being identified and therefore is within this database to be searched. And so I think that while we are talking about in this statute an actual child, it is not because we are dragging that child into a variety of courtrooms across the United States to have them come and testify and to provide whatever testimony. To the extent that maybe we're talking about cases where someone is charged with other crimes, but then also is engaging in like the production of this, you may have some of that testimony and you may have that existing within a charging document. So it's probably a little bit more complex than it is or it isn't, but I think that Mr. Villani maybe can add any additional context that I may have missed in that question.
Jacob Villani, Clark County District Attorney's Office. I apologize, Senator. It's hard to tell with my view who the question's being directed at. But regardless, when we charge these child pornography cases, generally we are charging them by device at the state level. There are no children's names or initials. It is you possess child pornography on such and such a device. So we would plead, say, an iPhone or an SD card or something along those lines. The only time when initials are going to come into it is when there is an actual child victim such that they're in the home, they're being videotaped, there are sexual assault charges that go along with that. Then we start being more specific about, hey, it's this person we're talking about. And those are always used with initials with minor victims.
Thank you. I think that does answer my question. And it leads me to my next question, which is, how do you anticipate initiating these cases where there is no original child victim without the technology it seems have been relying on, which is those hashes on those pictures that get shared without being altered? And I'm sure they're already being altered to avoid detection. And so is there new technology being developed, or do you anticipate there is some other mechanism by which we will start to find people who are possessing the AI or computer-generated images?
Jacob Villani, Clark County District Attorney's Office. So the database is constantly growing. So I expect if a bill like this is passed, they're going to start adding, and as they get passed around the nation, they're going to start adding AI child pornography to that as well. Where this bill really helps us is if we find, I expect to find regular child pornography along with AI child pornography. So the hashed images are what kicks off the investigation. What I'd like to be able to do then is if we find additional devices pursuant to that kicked off investigation during the search, and those devices contain only AI generated child pornography where it's clearly a child, again, I'd like to be able to prosecute that, and current law does not allow that.
Okay, that makes sense to me. And I have two more questions, and I'm not trying to be flip or anything. I think that we're living in a very strange time and a brave new world where people can manipulate images in ways that we might not expect. And so I'm wondering if this bill would capture, or is intended to capture, adults who consensually allow their images to be manipulated to make it look like their children.
Jacob Valani, Clark County District. I'm sorry, I can't tell who that was directed to.
So I will go ahead and take a stab at that, Madam Chair. Nicole Canizaro, Senate District 6. So I think that this is, first of all, if you are taking an image of an adult and you are purposely making this into a minor child, which then is depicted in some sort of sexual conduct and a sexual portrayal that does not meet the criteria of having some sort of artistic, scientific, literary value, you are generating and creating child pornography. That is absolutely an issue, and I think something that this bill is designed to get at. Now, I think really where this question lies, given some of my discussions on this bill, is somebody who is 18, who is trying to make themselves look a little bit younger. And I think that's really the question, right? We're not talking about maybe somebody who is a 45-year-old adult who is trying to make themselves look like or AI generating some sort of, 6 or 7-year-old. That question, I think, is where, when we get into this discussion about, are you somebody who is of age but is trying to make yourself look a little bit younger because maybe you have an OnlyFans page, and that's the sort of folks who are attracted to your page, as an example that was brought to me. And I think that is where this discussion then centers on whether or not we are creating a statute that is, first of all, addressing the issue of child exploitation, while B, also having sufficient constitutional protections that if somebody is just trying to make themselves look a little bit younger, does that fall within the parameters of child pornography? And I think what's helpful in all of this is that as you read some of these Supreme Court cases, they talk specifically about instances that are very similar, I think, to that particular and particularized example. That example, I think, number one, first and foremost, should not dictate whether or not we pass this bill or whether or not we choose to address this problem. There are never going to be, again, a law that is going to give us a bright line test that says this is in and this is out. Part of this requires for the judiciary, for law enforcement, for prosecutors and defense attorneys to make those kinds of calls. I would argue that a situation like that is not something that is going to find itself within the parameters of this bill. But let's say that there is someone who makes themselves look a bit younger in order to attract an OnlyFans page, and that's the sort of imagery that we are talking about. Whether or not that then falls within the descriptions of this bill, I think, again, are highlighted by the parameters regarding whether or not this applies to the prurient interest, whether or not this is something that has one of those redeeming qualities, and whether or not the work as a whole, whether or not this is sort of part of a brand that they are having, is really going to be a very fact-intensive question. And I know that's maybe not the answer that folks want to hear. They want to hear that, yes, if you are 18 and you have an OnlyFans page, you can do whatever it is that you like. Sometimes when we are writing laws, they may capture those incidences, and that's where we do have to make those sorts of calls. That is where we have to have faith in our judiciary. We have to have faith in our system of government. And I think when we're looking at whether or not we should pass this bill, whether or not it's going to pertain to every one of those instances, the answer is there's not going to be a bright line that's going to exist in this bill. And I would argue even under a situation where some of the amendments that have been proposed, that particular situation is not remedied by that language.
I wasn't sure if Mr. Valani, if you wanted to weigh in on that. I mean, I think the majority leader did an excellent job answering, but you can go ahead if you'd like.
Jacob Valani, Clark County District Attorney's Office. I completely agree. The indistinguishable language here, I think, really makes it clear. And like I said, when we're prosecuting these cases, it's clearly children. We have a burden of proof beyond a reasonable doubt to bring these cases. It's hard to distinguish when you're around that line of 18 years old, and those are not the type of cases we're taking. Those are not the type of prosecutions we are going forward with at this point in time.
Thank you. I appreciate your explanations. I appreciate all of you being here to present this bill and to answer all of our questions. I think I got all of the questions from the committee. And with that being said, we will move now into testimony. I am going to take testimony, obviously. I'm just trying to figure out if we need to limit it in total. Could you guys do me a favor? And everybody here to testify in support, could you raise your hands? Okay, and everybody in opposition. Okay, looks like we'll have plenty of time for everybody to testify, unless there are way more people in. Looking at Las Vegas, we have plenty of time for everybody. So I will go ahead and start with testimony in support of SB 263. Come on down and go ahead whenever you are ready. Thank you.
Good afternoon, Chair Scheibel and the Senate Committee on Judiciary. My name is Chris Reese. It's R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. First, I want to thank the bill's sponsor, Senate Majority Leader Cannizzaro, for this important and forward-thinking piece of legislation that will help keep our children safe and hold dangerous perpetrators accountable. We support SB 263. We are all becoming aware of generative artificial intelligence, or GAI, and its ability to positively impact aspects of our lives. However, we as law enforcement are also becoming more and more aware of GAI being capable of impacting very serious things very negatively. Specifically, GAI is being used to depict realistic images indiscernible from actual people, and shockingly, this includes sexually explicit child pornography of what appear to be toddlers, prepubescent children, and other minors, referred to as child sexual abuse material, or CSAM. However, there is currently not a law in the Nevada Revised Statutes where a person could be charged with AI-generated CSAM. Child pornography makes lasting, harmful, negative impacts to survivors and victims. GAI child pornography is no different. GAI CSAM is CSAM. We are deeply concerned with this harm when generative AI creates child pornography for children and society as a whole. This bill will close a dangerous gap in Nevada's CSAM laws, and LVMPD supports SB 263.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association. We are in support of SB 263. As already has been testified, we need laws to keep pace with technology, especially technology that facilitates child exploitation. I want to say we appreciate Majority Leader Cannizzaro and Attorney General Ford, both of whom reached out to law enforcement during the preparation behind this bill, and we are strongly in support. Thank you, Chair.
Okay. Oh, it is on. Okay. So, good afternoon to everybody here. My name is Nazrat Sarai. I'm actually with UNLV Honors College. I'm here to represent all of the students of UNLV. It is so wonderful to be with you all today. I'd like to share my at least personal experience of using AI, considering that I am a CS student and I am an art student. I've used a generative AI for professional projects as well. I think generative AI is extremely beneficial. However, considering that there's this huge controversy surrounding AI with given no compensation for what images it used to train their AI models, it's, to me, is very disgusting that the work that I produce, as well as the work of my friends and other artists, could be used to generate something that is extremely vulgar. Therefore, I am completely in support of a bill like this. I can't imagine the families who are innocently posting pictures of their children who are then victimized just because somebody decided to go and put it through an AI filter just to produce pornography. For anybody who decides to question if this goes against their First Amendment, I hope to point towards the Miller v. California case. And it is mentioned time and time again that this is not content that is used artistically. This is content that is absolutely disgusting and used for gratification, and I think we can all come to agree with that. My only real concern is just what was already kind of talked about, how you're going to be able to track this sort of thing. Realistically, the only way I could see that is maybe if you're going to these companies themselves and trying to go look into the accounts of people who have generated these images. But then that comes into the question of privacy, and it is a little concern. That could be cause for a huge concern as well for people who might protest against that. Ultimately speaking, I really appreciate everybody's presence in this meeting. It shows your dedication to protecting our children. In passing this bill, I hope that protection extends to the use of those who are using AI for at least benefit our society, especially given our enrichment. Thank you all.
Before you step away, could we have you spell your name for us, please?
Yes, it's Nazareth, Nazareth, like the Jesus of Nazareth. Yeah.
And is that your first name or your last name?
That's my first name. My last name is Zerai, Zerai.
Thank you so much.
Yes, thank you all.
Good afternoon, Chair and members of the committee. Jason Woodard, JASON, Nevada Sheriffs and Chiefs Association. First off, we'd like to thank the bill's presenters and also the sponsors on what is a very important piece of legislation. I'd just like to remind the committee, or at least talk about the fact that we know in law enforcement that when this type of material is generated, it has multiple impacts. And one of the more significant impacts is it creates a somewhat or relatively indelible record. And the more that that particular image is distributed, the harder it is to capture it and bring it back, and the more the victim is ultimately victimized or re-victimized because of the distribution of this type of material. AI just further magnifies that distribution capability, and as has already been discussed in this hearing today, also magnifies the ability for that image to continue to be morphed, and the morphing of that image makes it more difficult for us to essentially capture that and hold those in possession of it accountable. I believe this bill, which was, I think, laid out and articulated very well, helps to close the gap that's been mentioned several times and gives us more tools to try and limit the distribution and impact that such generated images have. We strongly support the bill and ask that you do the same. Thank you.
Good afternoon, Chair Scheibel, members of the committee. I am Jason Walker, JASON, representing the Washington County Sheriff's Office. Thanking Senator Cannizzaro and General Ford for bringing Senate Bill 263 forward. This bill addresses the growing concerns regarding the use of technology to create visual representations that exploit children. This is significant as advancements in technology make it easier to produce highly realistic images that can be indistinguishable from actual photos of minors. I feel it also makes it important of the need to adapt laws to keep pace with the tech advancements. Law enforcement needs to stay up as well with artificial intelligence to better thwart and or combat these situations. Thank you.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, C-A-T-H-C-A-R-T, representing the City of Henderson. I first want to thank the sponsors for bringing this legislation. The city is supportive of the definition additions, the penalty updates, and all of the conforming changes, and believe they will be useful with the ever-changing world of technology. We believe this is important public policy and urge the committee to process this bill. Thank you.
All right, I don't see anybody else coming forward in support in Carson City, so we'll go to Las Vegas for support testimony on SB 263. I don't see anybody coming forward in Las Vegas, so we'll go to the phones for support testimony on SB 263.
Thank you, Chair. If you would like to offer testimony in support of SB 263, please press *9 now to take your place in the queue. Caller with the last 3 digits, 996. Please press *6 to unmute yourself, and you may begin.
Good afternoon, Chair and members of the committee. My name is Brianna Cowan, B-R-I-A-N-N-A-C-O-W-A-N. I'm a little under the weather, so pardon my voice. I represent Douglas County Republican Central Committee and Douglas County Republican Women, and we strongly support SB 263. We thank the Majority Leader and other co-sponsors for bringing this very important piece of legislation forward. Child pornography causes severe lifelong harm to children, and expanding these laws is crucial to protecting vulnerable minors. AI-generated pornography depicting children normalizes harmful behaviors and perpetuates the exploitation of children. AI models must be trained. They are done so by submitting real images, acts, and content from which AI models then extrapolate common themes and content, which is then used to produce quote-unquote new content. AI trainers must then refine the AI's output to produce a more accurate response. This is extraordinary and corrupt. This exponentially exploits and victimizes our children. AI pornography is not a victimless crime. It begins with a victim or victims and perpetuates their abuse continually. We strongly support this bill, and we thank you for your time in this matter.
There are no further callers to offer a testimony in support at this time.
All right, then, we will go to testimony in opposition to SB 263, starting here in Carson City.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. Paloma Guerrero, Paloma Guerrero, on behalf of the Clark County Public Defender's Office. Wait, I'm so sorry. I was supposed to go second.
My turn. Good afternoon, Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. We are testifying today in opposition to SB 263. Currently, the Supreme Court of the United States holds that you must be an identifiable minor in order for these computer-generated statutes to meet constitutional standards. The use and function of AI has expanded and advanced all over the world, widely being used by not only tech companies, but by the general public, including children. AI is used in everyday life, from something simple like autocorrect in our text messages to developing complex computer-generated images for movies and television. Given the fast pace that AI is changing our lives, we see and understand the need to amend our laws to keep up with these changes. SB 263 seeks to close a loophole to ensure that those people who use AI or other computer-generated images to create child pornography are held accountable for their actions. However, when changing or amending laws, we should do so carefully. We should attempt to ensure new or amended laws are constitutionally sound and do not violate people's constitutional rights to free speech. We oppose SB 263 because the language violates the U.S. Constitution, and we are specifically talking about Sections 1A2 and Sections 1B. These are unconstitutional under the First Amendment. First, with the 1A2, the way the language reads, it's any person who is 18 years of age or older. This is not a minor that we are talking about. 18 years or older is not a minor. They are not a child. And second, when it comes to 1B, while we can agree that mixing different pictures of real minors together and creating a sexual image should be considered child porn, the image should be of an identifiable minor and not an animation or a cartoon. This language appears to depict would include animated images, which seems to be against the intent, which is to help actual children. Additionally, we fear that SB 263 will negatively impact juveniles who may share naked selfies or use AI to alter their body parts. There is no carve-out for these juveniles, and we believe that this statute, because other statutes provide a carve-out for juveniles, that one should be made, there should be an exception for these juveniles. No one in this room supports child pornography. We are all against it. But given the importance of this topic and its sensitive nature, we should have an increased duty to make sure that we get this bill right.
Paloma Guerrero, Paloma Guerrero, on behalf of the Clark County Public Defender's Office. And we're not up here saying don't do this. All we're saying is that the bill needs clearer, better language, because it can all be left up to discretion. Thankfully, we have Mr. Villani in Clark County that's making those important calls on when to prosecute, but that's just not the case everywhere in the rest of Nevada. And as a solution, we submitted an amendment that mirrors the federal language which courts have been analyzing and upheld convictions under. And if that federal language is adopted, we will remove our opposition. And our amendment is pretty simple. It changes the definition of computer-generated child pornography, again, to mimic that federal statute. And we also want to use the term identifiable minor to avoid the concerns that my colleague from Washoe addressed. The last part of our amendment just changes the penalties here for subsequent offenses, changing it from 10 years to life in prison down to 5 years to 20 years in prison. 5 to 20 years in prison is still a very, very, very long time, and it's a similar sentence to the charge of attempt murder. We can't have the only solution for this issue just be more incarceration. The focus should also be on preventing AI systems from being able to generate child pornography in the first place. Thank you.
Sorry about that. I'm still adjusting to the technology. For the record, Tahar Hasibullah, first name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. I serve as the executive director for the ACLU of Nevada. The ACLU of Nevada is opposed to this bill specifically because of the issues that were outlined surrounding Section 1, Subsection 1B, and Subsection 2. I want to begin, though, by thanking both Senate Majority Leader Cannizzaro and Attorney General Ford for being gracious with their time and meeting with us to address our issues. I also want to share, I'm well aware of the concerns that are addressed here. I spent my first 3 years as a juvenile sex crimes prosecutor in New York City. Spent the next several years as an attorney for people who were survivors of domestic and sexual violence here in Nevada. And I've ran the ACLU for the better part of the last 4 years, a little over that. As you're well aware, we've been at the forefront of most First Amendment issues. This falls right within that progeny. Section 1, Subsection 1B, and Subsection 2 overreach by expanding severe criminal penalties to include computer-generated images and AI-generated depictions when no real child's involved. This broad expansion raises constitutional concerns and risks criminalizing protected expression, as addressed by the public defender's offices. Indistinguishable here is largely vague. A judge could simply make a determination that one looks indistinguishable from a minor, and with no clear standard involved, a bevy of constitutional issues exist. The Miller test, I know, was mentioned a few times. The case was decided in 1973. There was no construction or consideration of AI-generated imaging at the time. That's why the Supreme Court precedent that exists turns on existing identifiable minors. But I want to explain how this approach, while seeking to end an AI-related child pornography loophole, actually creates a prosecutorial loophole that can be weaponized in a nefarious way, undercutting the First Amendment. And while I can appreciate that this bill is bipartisan, I'm simply not one that's going to trust the government. Most of my membership is not going to trust the government. I don't generally encourage people to do that. So I don't take the government at their word when they say this won't be misused. There is the ability within this bill for someone who is over the age of 18, let's say someone who's 25, who is an OnlyFans model, who has decided to make themselves look younger, if that's through pigtails, a plaid skirt, if that's through filters, to make themselves look younger, and theoretically they would fall under the gambit of a Category B felony, subject to prosecution under the statute, because of the vagueness surrounding it, despite the fact that they consent. Moreover, OnlyFans themselves or another tech platform that allows for such a category to exist, that owner would also fall under the gambit of this. So a person who screenshots an image and says, I can't believe so-and-so looks like this in an ad, they too could be subject to a B felony through this protocol. And as we mentioned with respect to juveniles, another area that pops up, they also would be subject to a provision of this despite being of the same age. There's not an artistic value that's associated with child pornography under the federal statute. That's been made clear, but what there is a clear definition of identifiable minors for that reason. You can't consent to being in child porn if you're a child. You're being exploited at that point. There is no ability to do that. For something like this, where it's AI generated, the constitutional issues abound. So I'd encourage this committee to vote no. Obviously, there's conflicting law on this. I'm sure it'll end up going up if it's passed. But for those reasons and the reasons outlined by our colleagues at the public defender's offices, we're opposed to this bill in its current iteration, again, based on those specific subsections that I've cited to. Thank you.
Thank you all for your testimony. I don't see anybody else in Carson City coming to the table, so we'll go to Las Vegas for opposition on SB 263. I don't see anybody coming to the table in Las Vegas, so we'll go to the phones for opposition to SB 263.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide opposition testimony at this time.
Okay, then we will go to neutral testimony. Anybody wishing to give testimony in the neutral position is invited to do so now. I don't see anybody coming to the tables in either Carson City or Las Vegas, so we'll go back to the phones, please, for neutral testimony on SB 263.
Thank you. The public lines are open and working. However, there are no callers to provide neutral testimony at this time.
All right, then that concludes testimony on SB 263. I'll invite the presenters back to the front to give closing remarks.
Thank you again, Madam Chair and members of the committee, for allowing us the presentation today. Nicole Canizaro, Senate District 6. I first and foremost just want to note that this is an issue that I believe very strongly we have to address. If left unaddressed, I think we're going to find ourselves in a much more precarious situation in the next legislative session, which would be the next opportunity we would have to create a law that is designed to get at what we are seeing in real time, adapt current exploitative material of children in a way that is designed to simply go around current existing law, to find a loophole, to find a way in which what we have already determined is criminal conduct and which already determined is a harm to our society and which we have decided to address. And so I would urge this committee's support. Obviously, I want to thank everyone who came in opposition for obviously having discussions with, I think, myself and I think also with the Attorney General's office about their concerns, and we'll continue to have conversations with them, but I do believe that we have to find a solution here. I think just one or two things that I wanted to address that we did not address in our conversations, but which came up in opposition, and again, remain committed to continuing conversations on this bill. When it comes to, I think, the focus on the indistinguishable piece of this, and whether or not that then opens up an avenue for a constitutional challenge, I think the important piece to note is that that language as it exists within Senate Bill 263 definitely is designed to meet that constitutional scrutiny. We're talking about realistic depictions, and that's what that language is focused on. And so this is an objective standard that courts have routinely applied when we are talking about these obscenity tests. I know we sort of touched on that during the discussion, but I wanted to just make that one note for the record. In as much as it concerns juvenile offenders, I think a couple of things. Number one, there's already current law that addresses whether minors are using electronic means and devices for sexual conduct. That is NRS 200.737. And so we do have laws on the books that talk about these sorts of things. We are able to address these issues and to craft a statute that is workable. I do believe that Senate Bill 263 does do that. And so again, we'll continue those conversations and hopefully continue conversations with the folks on this committee, but wanted to make those two notes for just our record here. And again, thank you so much for the time. I do appreciate it and appreciate all the questions from the committee.
All right, anybody else wish to make closing remarks? I'm going to take that as a no. Thank you all again for your presentation. I think I agree this is an important bill and it's an important issue to address, and it's timely. The longer we wait, the more complicated the landscape becomes with the advances in technology. And so with that, I will close the hearing on SB 263. And that takes us to the last item on our agenda, which is public comment. Anybody wishing to give public comment in person is invited down to the front now in Las Vegas and Carson City. I don't see anybody coming forward, so we'll go to the phones for public comment.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting for today. We have another meeting again tomorrow. We did recently publish the new agenda. We are hearing a bill, and we will also have a work session tomorrow. So take a look at that agenda for all of those bill numbers. And it's at the same time, same place tomorrow. Until then, we are adjourned.